What happens if a person is injured on a commercial property, such as a business, a parking lot, or an apartment complex? Well, my firm has been involved in cases where victims have been shot and killed, paralyzed, raped, or sexually assaulted. So how do we prove the commercial establishment is negligent by not providing security or by having inadequate security? Well, these negligent security cases are not easy. They're time intensive and they're very difficult. Let me give you 5 ways that we try to show the defendant business owner was negligent in protecting people on his property. Number 1, prior crimes. The most common way that we can prove a business is liable for these types of incidents is by establishing the company knew or should have known about prior crimes there. One way we do this is by securing the crime reports from the local police department through an open records request. Let me give you an example of a case my office worked on a few years ago. In January 2008, a family lived in an apartment complex in Atlanta. The father was in the parking lot when he was a victim of a robbery and was fatally shot. He did not know his attackers, and he was a totally innocent victim. The apartment complex in which he lived heavily advertised and marketed the fact that it was reasonably safe and the property was properly maintained. However, the investigation revealed that the complex was not properly maintained, inspected, secured, patrolled, or managed. When more investigation was done about crimes in the area, it was discovered that there were 13 armed robberies reported at the complex just in the 2 years before our client's tragic death. The apartment complex was on notice of a serious security problem on their premises, yet they did not do enough to protect the tenants that paid good money to live there. The complex failed to take any action to remedy or reduce the danger to its tenants and allowed the dangerous environment on the property to persist. Yet the apartment complex, they were still out there marketing that their units were safe. Well, the case settled for a very high confidential figure when the apartment complex and the insurance company was presented with the results of the investigation in our demand package. Number 2, the defendant business owner's internal reports. We also look to see if the defendant apartment complex or business had any internal reports which identified prior crimes in the area, as these are also admissible. Number 3, what security practices are in place. Another thing we investigate is what security practices the business has in place to protect the people that are invited onto its property. We can often establish a standard of care a business should use to protect others by showing what other similarly situated businesses do in the area. All right, number 4, prior victims. We may also interview prior victims of similar crimes at the property or in the area. We can get their names from police reports, and these are especially helpful if the crime occurred at the same location. Again, showing the business knew of the prior incident. And number 5, security experts. There are times where we may hire security experts to help us establish that the defendant business owner breached the standard of care by not having security when needed or by having an inadequate amount of security. Well, as you can see, the handling of a premises liability inadequate security case, it can be a challenging effort. And it's certainly not something that you'll want to do on your own. You need an attorney that is experienced in these types of cases. You have absolutely nothing to lose by calling me. But think of all you can lose if you don't.